then the bong hits for Jesus case, where it's just I'm not sure really, quite frankly, what the logical distinction is here. But I guess the First Amendment doesn't protect advocating for drug use. I don't know.
That case will never not be funny. But anyway.
I don't know if I've already telegraphed this enough through my tone, but the reason why I'm of two different minds is, on the one hand, I'm very strongly tempted to say Tinker was wrongly decided. That
Well, it's Monday morning. He's kissing Mama goodbye. He's up and gone with the sun. Daddy drives an 18-wheeler, and he's off on a Midwest run. And three sad faces gather around Mama. They ask her where Daddy's coming home. Daddy drives an 18-wheeler, and they sure miss him when he's gone. But he calls them every night, and he tells them that he loves them. He taught them to sing this song. Roll on highway, roll on along. Roll on daddy till you get back home. Roll on family, roll on crew. Roll on mama like I asked you to do. And roll on 18-wheeler. Roll on. Roll on! That's what Alabama said in 1984 with their hit number. But, ironically, it's hard to roll on if you don't have a truck stop. A place where you can fill up your rig, grab a bite to eat, and get a shower. Well, unfortunately, a county in Georgia decided that Daddy wasn't important enough to come home, and so they didn't allow a truck stop to be built. We're going to talk about that case, and also a case about come and take it when it comes to a hat, this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, May 15th, 2025. It's all about truck stops and hats with guns on them in schools this week. A couple of maybe a little bit controversial subjects, but we'll see what we can do with them. And I have two intrepid young IJ attorneys with me to sort these questions out. They are Suranjan Sen and Tahmineh Dehbozorgi. Welcome to both of you. We're first going to speak with Suranjan, and then we're going to get to Tahmineh, and she's going to tell us about this truck stop case that I'm intrigued to dig into. But first of all, Suranjan, so you're going to be talking about a case involving a kid wearing a hat in a school that had some controversial speech on it, and it was actually argued by our friend Eugene Volokh. But I have a question to start with you, Suranjan. Mm-hmm. What is your most controversial hat that you own? So if you put this hat on and you walk to, I don't know, a school, a workplace, whatever, people would be like, oh.
Well, Anthony, I'm glad you asked me that, because this has been something that weighs on me a lot, because, I have this hat that I love, but I'm really, quite scared to wear it in public. I feel like everybody's looking at me, and, I feel this case really spoke to my heart because of it. I am in my spare time a barbershopper. I'm in a barbershop quartet, and like any good barbershopper, I own a boater hat, which is a brimmed straw hat that was popular 100 years ago, just like all my favorite judicial precedent. And I hope one day I can have as much gumption as the little girl in the case I'm going to talk about later to wear it loud and wear it proud.
And have you ever worn it to school when you were doing such things?
No, I didn't wear it to school, but I have worn it to work. And I have to say, I experienced severe discrimination here at IJ. People were looking at me, pointing and laughing. They were asking me, did Halloween come early? Oh, what's is it dress up day? I think my constitutional rights were violated.
Do you think part of that was that it was just one of you and you weren't in a quartet? So if there are four of you with hats, people would say, oh, I get it.
I mean, in the barbershop community, we always say that the party goes on until there's only three guys left. So, yeah, it's everything's always better when you're ringing chords together. So, maybe that was it.
Well, Tahmineh, I'm not going to ask you about hats. I think we'll leave that aside. But I am going to ask you about truckers and truck stops. So we have this property rights case from the 11th Circuit about just a property owner trying to build a truck stop. But I'm intrigued. You said you're interested in this case because you have truckers in your family. So if you could tell us a little bit about your personal experience with truckers, and then we can move on to trying to build this truck stop.
Absolutely. Having trucker family members is an understatement. I would say my entire lineage was a trucker since trucks were a thing. And before that, they were settlers. And long before that, they were Kingsguard. So background a little, I'm originally from Iran. I moved to the United States on 4th of July, 2015. Some would say it was destiny that I came on that day. But my entire family, my grandfathers on both sides, my great-grandfathers on every side, were all truckers.
Wow. So you have 4 great-grandfathers who were truckers.
Yes.
That's amazing.
And my dad's side of the family, my grandpa and my great-uncle, they owned a trucking company in Shiraz, Iran. The Dehbozorgi Trucking Company was a brand. And my grandpa used to drive 18-wheelers and also like multiple types of trucks. He used to transport oil and diesel and things like that. Very dangerous stuff. And I have seen and heard a lot of stories about how difficult life of a trucker is. It was so difficult that my dad decided that he would not want to continue the family business, and he went a complete opposite direction, and he became a telecommunications engineer.
That sounds a little maybe less time consuming.
Yeah.
I would guess.
I have a great respect for truckers. I mean, they really, a lot of people these days, they seem to think that the products on the shelves come by magic, and I mean, this whole country runs on trucking, and so I mean, that's amazing.
Yeah, and also the other aspect is that anybody else in my family, which are very few of them who are not truckers, all have trucking licenses, including my father. So, you still have to learn how to drive a truck, even if you're not a trucker in the Dehbozorgi family.
So have you ever driven an 18-wheeler?
No, I have not yet.
Yet. Okay. Well, we'll wait
One
and see.
day.
So the thing about, as we heard in the opening, being a trucker is you need a place to stop and refuel, and that's hard if there's no truck stop. So what was the problem with this poor fella down in Georgia?
Mr. William Corey, he is my personal hero. He was fighting for people like my grandfather to have a place to rest and a place to get gas. And, given the fact that being a trucker is so difficult, a lot of truckers get into accident because they're sleepy, because they are deprived of basic necessities. And having truck stops, especially in a country like United States, where truckers have to drive long distances, is very important. Mr. William Corey, for 25 years, has been fighting with Rockdale County in Georgia to build this truck stop. Unfortunately, the Rockdale County was very dead set to not let that happen. So the case that we're going to talk about today is very important because it really illustrates the tension between the individual property rights and the authority of the local government to regulate land use and zoning laws. Mr. Corey fought for 25 years. That's almost my lifetime to build this truck stop. And at the end of the day, he got an 11th Circuit ruling that said, we don't think you should. And that was it. So here's what happened. So Mr. Corey had this piece of land with this grand vision to build this bustling truck stop near a busy highway. And he started in 1996 when he started acquiring property. But what happened was that when he bought the land, it was zoned in the C2 zoning code, so meaning that he was allowed to build a convenience store, even a gas station, but he would not be allowed to build a truck stop. But his property was at a prime spot by the highway, so it would be a really great place to build a truck stop. But because of the zoning restriction at the time, in 1996, he was not allowed to do that. So he decided to apply for a permit application. So in 1999, that's a year after I was born, he applies for a permit application to build a travel plaza to serve both cars and trucks. The county says, nope, that looks like a truck stop to us, and rejects his permit.
And it seems under these ordinances, it's a real hazy line. What's a truck stop and what's a gas station? There's just all this criteria. It's almost a I know it when I see it kind of thing.
Exactly. And that's why, like, Mr. Corey kept fighting, and the county also kept fighting back. So when his permit was rejected in 1999, he sued in state court, but he still loses. In 2006, the county updates this zoning ordinance to explicitly prohibit truck stops in C2 zones. And they defined the truck stop as places with services like truck fueling, repairs, and overnight parking. And but at the same time, if you look at the language of the ordinance, it's so unclear what could constitute that, because there are different types of trucks, there are small trucks, there are big trucks. Not all of them have the same fuel requirements or even height requirements. So maybe would a small truck be okay? How are trucks different from cars? So that was not really clear. But what was very clear from this ordinance is that they really did not like the fact that Mr. Corey was so dead set on building this truck stop. So they wanted to use every single legislative means that they had in their toolbox to prevent him from building this truck stop. But he was not deterred. So in 2018 and 2019, Corey teams up with Quick Trip. I don't know if you guys have been to the South. I know Suranjan is from the area, but I lived in Atlanta for a bit, and Quick Trips were my favorite places to go. So he.
So by the way, this is Quick Trip, Q-U-I-K Trip.
Yes.
Where I live in Minnesota, there's Quick Trip, K-W-I-K space Trip. Are they different outfits?
I've never been in Minnesota.
Like in one part of the country it's K and one it's Q. Anyway, I was struck by that. So there's more than one Quick Trip apparently.
I think that's a trademark issue.
Maybe that's why it's KW, because no one would confuse the two, of course.
We're confused now. Here's evidence.
The Wikipedia page, by the way, says Quick Trip with a Q, and then it says, not to be confused with Quick Trip with KW, the La Crosse, Wisconsin-based chain of convenience stores. So there you go.
Uh-oh. I guess it is a generic name. So Mr. Corey teams up with Quick Trip with Q and K to build a new travel plaza, which included a big convenience store with truck-friendly features like separate fuel pumps for trucks, wide turning areas, and he works with the county to propose the zoning amendments, but that was rejected. And he still applies for another permit. His permit application was denied, and he appeals it through the county and state court, but he still fails. But in the meantime, as his case is going, in 2021, the county tightens their regulations again. They refined what constitutes a truck stop, and they included things like truck scales and raised canopy for heavy trucks, which, again, I think added salt to the wound, given that still gas stations were able to function. Trucks could even go to other gas stations and still get gas, but just because Mr. Corey wanted to build a place where trucks could go there easier and get gas that was for bigger trucks, he was not allowed to open his business. And so in 2022, he sues in federal court, claiming that the county violated federal law, including Service Transportation Assistance Act, the Takings Clause, substantive due process, and equal protection. So for the purposes of this podcast, I want to focus mostly on the takings clause and the substantive due process claims because I think those are very interesting. The substantive due process, is a constitutional safeguard. It says the government can't make rules or take actions that are unreasonable or arbitrary, that they violate your basic rights, such as using your property. In other terms, the zoning law, like Rockdale County, must be rationally related to a legitimate goal, like public safety or welfare. It can't just be a random or spiteful regulation, and it could be struck down if the plaintiff can show that government is acting arbitrarily and capriciously. So the Corey's argument in 2020 for the 2021 ordinance was that it was unfair and it was baseless. Essentially, it was targeting his plan without any good reason. He has a property right to use his land for a business, but county, by passing legislation that specifically targeted him, was not allowing to do that. So the 11th Circuit didn't buy Corey's argument. Why? Because they believed the government. And what was government's evidence? This is where it gets really funny. So the evidence was that the government showed FBI statistics that there are more human traffickings on truck stop, pollution, noise, traffic jams, and an eyesore for the community. Well, one would argue that maybe a gas station also has those problems. Why trucks specifically? But the court doesn't really go into details. They just take government's word for it. And the other reason was that there are legitimate concerns about safety, environmental beauty, and things like that. Nobody likes to have a bunch of big trucks turning into the street. And, county doesn't like it. County says some people said they don't like it. And the 11th Circuit said we don't like it either. So they concluded that the government has a reason to ban this truck stop because it is legitimately related to protecting the community from eyesores such as trucks and pollution and noise and things like that. Mind you, at the same time, trucks could go to gas stations in the area and still get gas. So I'm not sure exactly how the county was solving this problem when gas stations were still allowed and not a truck stop. And also, since for the equal protection issue, Mr. Corey argued the same thing. You're treating lands differently based on their use, and it's just not clear. 11th Circuit completely rejected that argument. And for the takings clause, Mr. Corey argued that the government is pretty much taking his property by this regulation, and they said, well, you didn't apply for a permit under the 2021 ordinance. Everything else you did was for the previous versions of it. You have to exhaust all the way. Mr. Corey came back and argued, well, what's the purpose? Because it's so clear that even if I apply for this permit, I'm still going to get rejected. And this is an argument Suranjan and I have every day about when we're looking at clients, where do you stop when you're exhausting? And here it is. This is the biggest headache of public interest lawyers who care about zoning laws. These exhaustions that are we know are completely baseless. It's not going to get anywhere. But the court says you still have to do that. You have to go all the way through the channels. You have to spend all the time and money and get rejected and then come here to the federal court and complain.
Right, and this is even post Nick, which is a case that they cite in here that Nick said from 2019 Supreme Court case that you don't have to exhaust, and I'm probably going to get this wrong, but you don't have to exhaust through your state court system your takings claim, but you do need to get a final ruling from your government, local government, on whether what you're trying to do is against the rules or not, basically. Is that right?
That's the narrow view of it.
And what is the wider view of it, Suranjan?
So there's a question of exactly how far, what counts as exhaustion. Is it limited to state judicial remedies? What about state administrative remedies? What about, because there was a recent case, I can't remember where it was, where it was similar to the home equity theft case, the Tyler versus Hennepin County. Their friends at PLF argued, except the state had a procedure where after they stole your home equity if your house was subject to foreclosure, and then because you owed the city a certain amount, and then they keep the amount in excess, the Supreme Court had said that that's a taking. They're supposed to allow you to keep the excess. This state kept the excess, but theoretically they had some procedure whereby you could, file something, and then maybe the state would give the excess back to you. So basically, they're flipping the burden of, rather than them having to give you the excess, they're going to take it unless you come ask nicely, and then maybe they'll give it back to you. And somebody filed a federal 1983 takings claim, and they were told, well, it wasn't you didn't exhaust the procedures for getting your money from the excess home equity, and notwithstanding Nick, because they narrowed Nick to just being about like judicial,
Right.
like not having to pursue a state takings claim, but not preventing the state from allowing other like administrative kind of, basically to quote Justice Thomas's concurrence, they're taking a kind of just sue me approach.
And so, Tahmineh, that's basically what ended up here, is that because they didn't go through this, what I would agree would be a fruitless exercise with these same people to get a variance where they've been denied before, then there's no takings claim.
Yeah, in a Persian language, we have this idiom says asking for justice from the unjust. And that's almost what is happening here. And I think in a lot of instances where the court hinges on this issue of exhaustion, it's like everybody knows that this is going to be fruitless and it's a waste of time. But, 11th Circuit says you have to go through the administrative process through your county, apply for the permit, get rejected, and then your claim is ripe for consideration for taking. And Mr. Corey had not done that under the 2021 ordinance, which was even a tighter language than the previous ordinances which he applied for and got rejected. But here we are. This is a very important precedent for anybody who's considering starting a business in an area where the zoning code doesn't allow in 11th Circuit, because the court has taken a very expansive view of the rational basis test for the substantive due process. The cases they cited, like Doe v. Moore, that case was about the government desire to protecting its citizens from criminal activity, was a rational basis for a law requiring sex offenders to register their status with local sheriff's office. The other case they cited was Haves v. City of Miami, which was about concerns about pollutions and visual intrusion were rational basis for the ordinance prohibiting houseboats. And the other case they cited was the Town of Jupiter case, and that was about cities have rational basis to prevent car dealership if they want to have aesthetically pleasing downtown area. I mean, I think all these cases are all over the place, and it just sounds like the county and the 11th Circuit really did not like the fact that truckers needed a place to stop, and maybe that area could be a good place for them. And as a member of a trucking family, I really feel for Mr. Corey, because I understand the anxiety that the families of truckers feel when they know that their loved one is on the road and they need a place to stop. And if more places across the country are preventing these truck stops to be built, then we're going to have a problem.
Yeah, I think this case illustrates something that anybody who's a regular listener of this will not find particularly surprising, sadly, that of courts routinely disrespecting property rights, routinely acting as though, it doesn't really belong to you, it belongs to everybody. I mean, this, to the extent courts don't feel like being super review of zoning boards, then there's a really easy fix for that. Let's end zoning. I mean, this is basically feudalism. the town saying, we think that won't look pretty, or oh, we think that maybe if you have this truck stop, some of the people will come by, and we don't like those people. This is clearly exclusionary zoning. So I mean, there's reasons to be on an equal protection level, on a even maybe perhaps dormant commerce clause type analysis of being skeptical of this, even if you aren't an ardent defender of property rights as we are. But at bottom, whose property is this? Does it belong to me, or does it belong to City Hall? And cases like this remind us over and over again, we don't really own what we have. And I don't mean that in a kind of like sovereign citizen way, but I mean it's like, I'm not allowed to build a truck stop on my property where I'm allowed to build a gas station. Come on, and again. Either in the substance, the courts routinely act like you don't have such thing as a right to use your own property, and then in the procedure, they do everything they can to get out of even having to deal with the substance at all. I'm hopeful that the second prong of Williamson County, which is the finality prong, which was what the court dodged the takings claim here. I'm hopeful that it's not long for this world, and as part of generally the whole very notion of prudential ripeness. I mean, if there's some sort of case where the locus of your claim is that I'm being prevented from earning a profit from my property, and the government must allow me some sort of way to earn a profit, then I can understand there being some notion of, well, how can we know that until we know what the government's going to allow you to do? But if what you're saying is, look, this is about profit, this is my property, I should be able to build this thing, I don't understand if your argument is that they don't have the ability to say no, then why should I have to go through this and have them say no first? Declare they can't say no. And what's the problem here? And it's because the courts just don't want to deal with this.
One sad end note on this also is that it was so this is a 35-acre property. The court says that he acquired in 1996, and he's actually sold it since the case ended. I don't know if he sold the whole property, or there was the last request was only 6.7 acres of that 35 acres to develop the truck stop. So he had this one statutory claim that the court didn't rule on because he didn't have the property anymore, and that he wanted an injunction about that property. But in any case, life goes on. You fight this for almost 30 years. Of course, someone's going to, for whatever reason, hopefully not too bad of a reason, going to need to sell the property and move on with your life if it's an investment property. But one thing I was thinking about that is, so it seems like he really wanted a truck stop, not just a gas station. And I'm guessing the difference one, a truck stop's probably bigger. Like, we've all seen those massive, gas stations, truck stops, the side of the highway that sell everything on earth instead of just a few bags of chips and a couple ho-hos. But in addition to gas, I'm guessing also, though, that a truck stop, when you have big rigs filling up their tanks, you make a lot more money on selling that diesel to a massive truck than all the just individual cars coming by and filling up with unleaded. Tahmineh, is that probably right? And is that maybe the basic economic thing going on here? And that might point to the value differential between these two as a truck stop and a gas station actually would be substantial enough that maybe there was a takings claim there. Because usually for a takings claim, you do need a pretty massive difference in value.
Yes, absolutely. And when he bought this property early back in the 1996, he wanted to build a truck stop. I think you're absolutely right that there are more profits to be made from a truck stop. It's a different market, less competition probably in the area. His property was located in a place that was pretty strategic for having something like that, and obviously he didn't have to compete with gas stations. That's why he wasn't building a gas station. He wanted a place for trucks because he wanted to enter the market for trucks, which is a pretty massive and very lucrative market. And it's not just gas. Trucks need repairs all the time. They need to change their tires all the time. Obviously, having overnight lodging places for truck drivers to stay, that's important. And so it's a completely different ball game than a gas station. But he would still be able to sell gas on the property to cars as well. So
Right.
it's just like a larger business than a gas station. That's what the county ultimately did not want to have in the area.
The only silver lining here, I guess, is that this particular case, I'm not sure why, is unpublished. But unfortunately, the rational basis precedent, as Tammany already laid out in the 11th Circuit, and as we at IJ probably know all too well, is pretty bad. Rational basis precedent at the Supreme Court and elsewhere is bad, but there's rational basis and there's rational basis, as we often talk about, and sometimes you can win a rational basis case when the government is basically dabbling in pure fantasy, as the Fifth Circuit put it in one point. But I think as circuits go, the 11th Circuit is even worse than other circuits, and so this is an example of that.
Yeah, you can rationalize about any like monstrous thing, you know. If the notion that, well, the people in the community think it'll be ugly, okay,
yeah, then
that
enough.
satisfies it. Okay.
And sometimes in state court for zoning law, especially when it's just a statutory claim, aesthetics is not enough. Often it is, often not. I don't know. I don't read the cases in Georgia state court about this matter, but sometimes that can work in state court. So this is property rights, where you have it's very easy often for the government to win. Free speech, we like to think that's where the government's on its heels and the individual has a really good chance of winning in court, but not for one little girl in Michigan. So, Suranjan, can you tell us her story?
Sure. We'll call her the little girl. Her name is in initials in the opinion, and so I'll respect that. In this Michigan school, this little girl, she's, I believe, something like 8 years old. She's in third grade. The school had a wear a hat to school day. You're ordinarily not allowed to wear hats during in classrooms, etc. at the school. They had a wear a hat to school day. It was part of some series on, I think it was like showing kindness or something, which I'm not sure what that has to do with wearing hats, but maybe you could express that kindness through your hats. Her way of expressing that was in wearing a hat that had a picture. The court described it as an AR-15 style rifle. I don't know exactly what that is. I don't know if they meant that just because AR-15s are kind of a popularized, rifle, or if it was actually that. But let's say it was an AR-15. And on below it said, "Come and take it." And so some of the teachers were disturbed by this, and they talked amongst themselves, said they thought this might violate school policy about displaying weapons on clothing, and that it might cause a disruption. And part of what was on their mind, or so they testified, was that only a few months earlier in Michigan was a very sad, very tragic mass shooting in a school that was in the same county as this school, and a few of I think 4 students in that school were murdered, and it was the worst school shooting in Michigan in history, and a few of the students from that school had transferred to the school in question that is the subject of today's discussion, and so the teachers were concerned that such depictions of a firearm might upset those students. The teachers testified that they were concerned that the statement "come and take it" might be an invitation to some kind of disorder. That students might view it as a kind of a taunt to take the hat, and so one of the teachers asked this little girl, told, whatever, to take it off, and the little girl took it off and put it in the locker without any real issue. I'm sorry, and oh yes, she took it off, and then they called her father, and told him what happened, and asked if he would like to send a replacement hat to school so that she could still wear a hat to school day, and the father refused. And then shortly thereafter, this federal lawsuit, was filed on behalf of the little girl, but as the father filing it as her in legal terms as her next friend. The court upheld this. The girl argued that this was a violation of her right to expression, her right to free speech, and the court disagreed. And so, what's interesting here is I'm on two minds about this. And before I get into it further, let me first say that the attorney who argued on the girl's behalf was our dear friend Eugene Volokh, who is a brilliant law professor in California. I've had the pleasure of meeting him multiple times. He and IJ, I'm sure, have co-signed amici briefs, and
he was a guest on this show.
He's a guest,
just a few episodes.
So your listeners are well acquainted with Professor Volokh, and I've had the pleasure myself of meeting him multiple times, and I have a great deal of respect for him. And my hat's off to you, Mr. Volokh, for fighting the good fight.
But I feel a butt is coming, Suranjan.
So and that takes me to where I'm at two different minds here. So under the Supreme Court doctrine, there's this case going back to 1969 called Tinker versus the Des Moines School Board, something like that, Tinker, which established that students have the right to symbolic expression in schools, subject to certain narrow exceptions. And it's that they under Tinker they have a right to symbolic expression so long as teachers wouldn't reasonably forecast that the expression would cause a substantial disruption to classroom activities. And then since then, there's been several more ad hoc exceptions that have come up to this doctrine.
Like nonsensical speech, like bong hits for Jesus.
Yeah, like you're
it was okay to punish.
Yeah, so at first it was said that if it would reasonably cause a substantial disruption, and then there was if it's about obscene or sexual type language, that's the kind of stuff that wouldn't even be protected under the First Amendment anyway, and which, okay, fine. Then you have the speech that could possibly be mistaken for being endorsed by the school itself. So if it's some sort of school activity where they're wearing it, and it could be seen as the school itself speaking. And then the bong hits for Jesus case, where it's just I'm not sure really, quite frankly, what the logical distinction is here, but I guess the First Amendment doesn't protect advocating for drug use. I don't know, so
that case will never not be funny. But anyway,
I don't know if I've already telegraphed this enough through my tone, but the reason why I'm of two different minds is, on the one hand, I'm very strongly tempted to say Tinker was wrongly decided, that Justice Black, notwithstanding his needless dig at Lochner, I think his dissent in that case was probably right, in that, I'm not willing to say that students have or shouldn't have any kind of free speech rights in the classroom, especially now that we're well past the founding, when at the founding of this country it was entirely private schools, but I'm not sure if you get a bad grade in a math test because the teacher knows that you support the Republican Party, then, okay, I'm willing to accept that that's wrong. If you get expelled because you went to some political rally on your own time that had nothing to do with the school, fine. But the notion of purely symbolic speech, the notion that you have the right, even like a presumptive right to show up wearing a hammer and sickle armband or the Nazi swastika to English class just seems to me to be like a little bit too far, and I think to reflect somewhat of not to seem too much like an old stodgy fogey, but too much of the notion that a student's role is supposed to be to protest. I mean, you're here to learn. I'm not sure that's really an appropriate place that we should have to recognize this, but we do. That's the law, or so that's what the law supposedly is. Though again, who knows what other ad hoc exceptions they're going to come up with this law, which I think is with this doctrine rather, which is itself evidence that it's unworkable. But I digress. We have Tinker. This is a court of appeals that has to be bound by Tinker, and given that Tinker's on the books, I think that the circuit court got this one wrong. So the problem with this whole notion that you can suppress a student's symbolic expressive speech if you can forecast reasonably that it would cause substantial disruption, including disruption by other students, is endorsing a heckler's veto. Tinker itself was... they were wearing armbands in protest of the Vietnam War. And so it just so happened in that there wasn't much of the record that there was, I think one student said, "Don't go near me with that." Okay, but I guess if it angered enough students, then they could have taken it off. It's sort of, if your right to free speech, ends at where it's going to, makes other people angry, then what's the point then? I don't know what this is actually protecting in practice most of the time. And it seemed to me in this case, what the circuit court was really thinking, and there's a few clues in the opinion that they were really thinking this, is one, I don't think they really bought that this was the student expressing her political beliefs. There's a few footnotes where they mention how they suggest maybe it was more her father. And
there was a lot going on with her being 8 or 9 years old.
Yeah, and her age. And so I think to distinguish this from maybe like some 16-year-old student who, maybe has more of an idea about what, when asked at her deposition why she wore the hat, she said, "It makes me feel safe." And then, now granted, they didn't actually ask her, so it wasn't a political expression or anything like that, which, Professor Volek ably pointed out in his briefs, but nevertheless, I think that it was in the back of the court's mind, fairly or unfairly, that this wasn't really the student having her expression violated. That it was more the father trying to launder his expression through the daughter. I think the other thing going through the court's mind, and they say this outright, is because of that shooting that took place a few months earlier. However, it seems from all of the record in this case that what was going on in the teacher's mind more was that they themselves were offended by it. There wasn't really anything in the record to suggest, beyond the fact that there were students from the other school that were in this school, it seemed to me kind of a retroactive kind of way of justifying it after the fact. That it wasn't advocating for violence. "Come and take it" is a phrase that has a deep history in this country, that was used in the American Revolution, that was used against, I believe, correct me if I'm wrong, Tahmineh, I believe it was used in defiance of your ancestors by the Greeks fighting off the Persians thousands of years ago.
I don't think that's accurate, but I'll take it.
I think
I'll take it.
Maybe no, you won't. You will not take it. You can come and take it.
Associated with the Battle of Thermopylae. Let's see here. And it wasn't like, I could imagine something like Will wearing a hat that says "I'm going to shoot you" or something like that, or wearing, or if God forbid if somebody wore a shirt that said something like "shoot the school" or "school shootings are good." I don't know. Like, I could see something more, but something that does, whether you like it or not, we do have the right
to access firearms in this country, and it's I mean I feel like the turn from necessarily equating expressing support for that right with expressing some kind of support for school shootings is a bit far, and I the she also, or rather, Professor Volek also pointed out that if the so-called recent rationale was to ban all weapons, so ban all displays of weapons, that would ban a hat that displays the Michigan seal or the Michigan state flag. I can't remember which, maybe both. Depicts a rifleman. Because again, this wasn't actually depicting violence. It was a picture of a gun. And so, I mean, none of the other students, there was no record that there was any other student that was bothered by this hat. It seems to me, again, the court does cabinet with, look, there was this shooting a few months ago, but, I mean, and the shooting was in the same county. I understand that. I'm not saying that this hat was in good taste, but the whole point here is that if the First Amendment does apply, then the First Amendment doesn't allow you to prevent somebody from wearing a hat because you think it's in bad taste. And so I think ultimately, though I'm inclined to disagree with the whole premise of this doctrine, if I have to accept it, I think the circuit court got it wrong here.
Tahmineh, you seem a little bit more into Tinker than Suranjan, but I'm guessing you come out the same way.
Yeah, actually I do. The reason why I support Tinker is not necessarily because of the legal analysis. I agree with Suranjan that Tinker actually leaves a lot of wiggle room, as we see in this case, for the courts to have a cop-out to still go against First Amendment protections. What I like about Tinker is the policy or the rationale behind it is that, we want schools to be, safe environments for people to learn, but also at the same time be able to express themselves in a place where they're not scared or judged by the administrator. I grew up in Iran. I'm very much familiar with the feeling of being an edgy teenager who likes to dress differently but can't because they're scared of are they gonna get expelled if they believe a certain thing? Are they gonna is the school gonna call their parents and complain? So these are I guess things that if I was a Supreme Court justice, I would side with the kids and be like, hey, you should be able to be yourself and learn, and your environment should be a safe place for that. And obviously, I mean, teenagers, children, they haven't really, they're learning. They're still not set on a political belief. Maybe they don't know what's the significance of a symbol or something, or maybe they do, but at the end of the day, they shouldn't face retaliation or punishment, and I think it's really important to make sure that doesn't happen. The example that you used for teacher, math teacher penalizing you for going to a political rally on your own time, I think that's a very significant threat. I mean, it happened to me. My chemistry teacher, when I was in ninth grade, she penalized me because she was a very religious woman, and I said something that was controversial in the classroom during break, and she heard me, and then she wrote a comment on top of my exam paper, and that kind of stayed with me. Even until today, I think about it. It's it's really important for children to feel like they can be themselves in school. Obviously, as long as you're not infringing on other people's rights, and that's just a basic First Amendment principle as well. I mean, rights are not absolute. They end where someone else's space starts, and we should also keep that in mind. And I think the court here really muddied the water there. As Suranjan said, and I absolutely agree with him, I think the teachers didn't even understand what the significance of come and take it even is. They saw the gun and they kind of shut down, and there's the slogan itself is not really about that. There's a historical background.
Although in context, they would say, right, in context, putting it with that gun, it's about gun rights today, or about banning the AR-15 today. It's not about the Battle of Thermopylae or American Revolution.
Well, actually, what they were saying is that they were concerned more that the students wouldn't even necessarily perceive that context, but that they would view it as come and take this hat.
Take the hat, right? Well, when you're 8, perhaps they have a point.
Yeah, and I think another way of looking at it of the analysis the court used here, and maybe this is the analysis invited by Tinker, which again I find unworkable, but is that is less of a kind of First Amendment analysis and more of the kind of analysis that the rational basis test should be, which is if rational basis, a real deferential, though real, standard of rational basis applied here, then I think that the court would have gotten that right. In that, like, it's certainly, it's reasonably conceivable that wearing this hat could cause some kind of disruption. Do we have to wait until the disruption happens? Do we have to be able to, provide students testifying saying, oh yeah, I was about to do it? If I look at it and I think, I think there's a reasonable chance that something like this could happen. From here, sure, yeah, there's hats is come and take it. Yeah, it's a picture of a gun. Then that's. But if we're gonna have this kind of you have First Amendment rights, but also you don't really have First Amendment rights. It feels to me like it's just an invitation for picking and choosing, for figuring out that, oh yeah, you can do this, but not bong hits for Jesus. Oh, you can wear a pride hat, that's gonna make people uncomfortable for whatever reasons, and but you can't wear a hat that's celebrating an explicit constitutional amendment. And it's just as I said, maybe the bottom line is this is why we should be advocating for more robust school choice programs and just having get the students out of the government schools.
Well, I 100% agree.
Some of this was discussed in I think one of the most interesting cases from the last few years, which is the angry cheerleader case from I think 2001. It came out where there was the girl who said some things on, I think it was Snapchat, about school activities, but it was on her own time on the weekend, and then she was punished, and then the court said, well, what do we do about this? And essentially it was, they said her speech was protected in that case, and the school was wrong to whatever the punishment was against her. It came out of Pennsylvania, if memory serves. But the interesting thing in that case is both a little bit in, I think it was Justice Breyer's opinion and then Justice Alito's concurrence, was they point out, like, these are public schools, and you can't have, when you have a school, yes, it's the government running the school, right? We've crossed that bridge. Government runs the school. Like you were just saying, Suranjan, if everything was private, it would be easy. But we do live in a world where at least some schools are run by the government. And so the Constitution applies, but it's a school. And you can't just have strict scrutiny for, speech. Like, what if I write an essay on a subject that they didn't tell me to write it on? And I say, well, strict scrutiny applies. That's content-based restriction on speech. And it absolutely is a content-based restriction on speech. But it doesn't make any sense. And so how the court does this does a First Amendment analysis, it has to be kind of, pieced together. And maybe Tinker is just a way to do that. And maybe it doesn't make sense sometimes, but at least it's a way. And the argument, I think, would be is like, maybe this is the best we can do, or maybe it's not the best we can do. Maybe Suranjan's right, and there's other ways that we can do this, but at least it's a way of getting there, where we have, right, these black armaments in the Vietnam War. They seemed like they were good to protect that speech, but if it was more disruptive, maybe that's not great for the classroom. I don't know. There's no easy answer, but we'll leave it at that because I don't think we're going to figure it out today. So thank you, Suranjan, for your analysis of that case. Thank you, Tahmineh, for your analysis of the truck stop and for your trucking family history. I think that was fascinating for us all to learn, and maybe we'll talk about it in a future time. But for now, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.